briefly address then the ideas that I've come up with, or some of the things that I think can be done within the tort system under existing equitable law that can address some of these concerns. Now, kind of building on Professor McGovern's overlapping circles approach, the bankruptcy trust recoveries don't have a specific parallel in existing law. I mean, workers' compensation remedies are coming from an employer whom we've determined is, for whatever reason, held not at fault under the law. These are recoveries that come from people who were tortfeasors but ran out of money, but they are paying on asbestos exposure claims. I mean, this is remuneration for exposure to an asbestos-containing product. These aren't collateral source recoveries. These aren't insurance recoveries or something that somebody purchases or their employer purchases from them that they recover. I mean, this is a recovery based on an exposure from asbestos to a company or a trust that sits in the place of an entity that supplied those asbestos-containing products. So, getting to the point of what it is that I think the answer is to this problem, if everyone keeps in mind an objective of treating trust recoveries as closely as possible to recoveries from active tort defendants, or treating the system as if the people paying are still in. Now, I get the problem, and that's why I say as closely as possible, that trusts paying 10 cents on the dollar, 15 cents on the dollar, can't be treated the same as an active defendant that's paying claims at a negotiated value. And that certainly has to be factored into any of these solutions, that these are not full recoveries, but they are recoveries. And if we keep in mind that the plaintiff side isn't getting everything out of these recoveries that they want, and the defense side isn't getting everything that they want, at least there could be some midpoint where both sides are getting something from these recoveries, or both sides are entitled to some benefits of these recoveries. Again, I talked about transparency. It's been a very popular solution. There's a lot of court orders that you can find in multiple jurisdictions that talk about transparency, compelled discovery of bankruptcy trust forms, etc. It's a starting point to the whole process. Obviously, you can't even think about these issues without having transparency and know what trust claims are being submitted. But again, it's a starting point, not an ending point. Now, the next topic, and really where we get after transparency, is what can you say to fact finders about bankruptcy trust recoveries? And this is probably going to be the biggest source of dissent between plaintiffs and defendants on what is the relevance of this information. There's a split in the case law, and it's kind of a developing case law, about what these trust claims are. Are they offers to compromise, or are they proofs of claim more like a complaint than they are an offer to compromise? And admittedly, coming from only one side of this, in my practice, I've always raised the argument of what is being compromised. I mean, there's a lot of negotiation that takes place in bankruptcy court when these TDPs are being negotiated. There's a lot of back and forth as to how much money goes in and who gets paid and in what percentage. There's not a lot of compromise being made in an asbestos claims form submission. The money's there. If the claimant was exposed, he checks his right boxes, he fills out his form, he attaches his medical report, and he gets paid. He can choose either to be paid or not to be paid. If he chooses to be paid, he's not compromising any claim. And if he chooses not to be paid, he doesn't really reserve any claim for himself. So, at its core, these don't seem to be offers to compromise that would fit within the literal language of Rule 408. There are two California decisions, and for any California lawyers in the room, you can cover your ears because I'm going to talk about an unpublished decision. But there's a published decision in Volkswagen of America, and then there's an unpublished decision in Sea River that deal with this issue. And that's in the discovery context. They came out with the view that these are not offers to compromise. These are proofs of claim. They're like complaints. There's no reason why they would be protected from discovery as settlement discussions, and therefore they would be discoverable. Now, in a recent Ohio decision, In Wirtz, the court took a contrary view regarding admissibility of the claims forms to prove exposure to an asbestos-containing product. Now, in that case, the party stipulated to 40 different exposures, and the one depicted in the bankruptcy trust form was one of those exposures. But the verdict in that case was in favor of the defendant, and the error of allowing the evidence in was found to be harmless error. So it didn't go anywhere further in the appellate process, and that decision is out there, and I'm sure it will be cited for the proposition that the proof of claim forms are offers to compromise, and so there's a conflicting point. But the question is, if these aren't offers to compromise, and the payments are coming from a tortfeasor or someone sitting in the tortfeasor's shoes, why aren't these admissible as admissions of liability by an entity that supplied asbestos-containing products to which a plaintiff was exposed?